So you may have heard people talking about the changes to 42 CFR Part 2, the federal confidentiality protections for substance use disorder treatment records. What do these changes mean for you if you are considering treatment, or you're currently in treatment, or maybe you've been to treatment in the past, so you have past substance use disorder treatment records? This short video is for patients and peers, and it just highlights some of the key changes to be aware of. These changes were first introduced in 2024, but we're talking about them in 2026 because there's a big compliance deadline on February 16th, and so this is when the changes are really going into effect. First of all, what is 42 CFR Part 2? Many people are more familiar with HIPAA, but Part 2 is another federal law that's actually much more protective than HIPAA, and it applies specifically to substance use disorder treatment records from Part 2 programs. Not all SUD treatment happens in a Part 2 program. If you're not sure, you just need to ask your provider. They have to know the answer, and they have to be able to tell you, are you covered by 42 CFR Part 2? Yes or no? Now, Part 2 is a stronger confidentiality standard than HIPAA in a number of different ways. First, Part 2 strictly prohibits undercover officers or informants from gathering information and using it against a patient in a criminal proceeding. Second, Part 2 is generally more protective of patient confidentiality in response to any inquiry by law enforcement. That includes local, state, or federal law enforcement, and that also includes immigration authorities. And then third, Part 2 is unique in that it generally requires your consent as the patient before sharing many types of records in many different ways. So even when sharing information with another healthcare provider, or billing insurance, or sharing information with a CPS investigation or your friends or family, Part 2 generally asks, did the patient sign a written consent authorizing this disclosure? And so it gives you a little bit of extra power about deciding when and how information from your treatment gets shared with other people. Now, following recent changes to the law and regulations, it is more important than ever to be reading the consent forms carefully before signing them. You can always ask questions about what a consent form means. You can always ask, what exactly is this consent form saying that I'm authorizing? You can always ask, is it required for me to sign this consent form as a condition of treatment? And you can always ask, is it possible to make any changes to this consent form? If you want to authorize disclosures, but maybe to a smaller selection of your primary care doctors, but not your dentist. Or if you want to share some of your substance use disorder treatment records, but maybe not the entire treatment history, you can always ask if it's possible to sign a more limited consent. One of the big things to look out for with these new changes going into effect is that programs may start asking patients to sign something called a single consent for all future uses and disclosures for treatment, payment, and healthcare operations, or a TPO consent. This consent is convenient because you just have to sign one form, and it allows the program to share information with you or about you in lots of different ways. With your healthcare providers who need information to provide you healthcare, with any insurance company or third-party payer that's paying for the services. However, if you are concerned about sharing information with all your treatment providers, this consent may not be the right fit for you. Many people prefer to share information with certain trusted doctors or practices and don't necessarily want every new dentist or dermatologist or emergency room to have access to their entire treatment record. The other thing is that this new single TPO consent makes it easier for the people who receive your substance use disorder treatment records to use and share the records with other people. And eventually your records may lose their special protections under Part 2, including those protections that I named about preventing information being used against you in a criminal case. The TPO consent causes your records to eventually lose their protections as they move downstream. A few other changes to highlight from the recent amendments to Part 2. It will now be easier to file a complaint for a violation of Part 2, and it's much more likely that complaints will be investigated by the Office for Civil Rights in HHS. Programs cannot retaliate against you for filing a complaint or exercising any of your rights under the federal confidentiality law. For example, what does retaliate mean? If you file a complaint that your opioid treatment program violated confidentiality, they couldn't use that as a reason to revoke your take-home privileges or say that it's evidence that you're not complying with treatment that you're complaining about the confidentiality breach. Many people also want to know how the changes will impact past substance use disorder treatment records. Maybe you've been out of treatment for a year or 20 and want to know what these changes mean for your old records. The short answer is that the changes shouldn't impact old substance use disorder treatment records, but the more realistic answer is that there's a lot happening right now in the law and also with health information technology and technology in general. And this is really something that we're paying a lot of attention to see how we can continue to advance and defend people's confidentiality, past, present, and future. If you have a question about confidentiality or would like to see more short resources like these or in writing, please comment below or send us an email to privacy@lac.org. And we have many more resources available on our website at www.lac.org.